Good afternoon. How's everybody? Good afternoon. Welcome to another Government Department Pizza and Politics event. This is our third of the semester, which is great. We may have another one. Thank you for coming. I think there's a bit more pizza and soda out there. Each day, each time we open the news, we get yet another installment of how terrible, atrocious, horrific this war in Ukraine has been. And if you're like me, we've wondered, will there be accountability? Can we do something? Will Vladimir Putin be pulled into justice, drawn to justice? It's a complex question, as we all know, but thankfully we have an expert here in the Government Department on this topic. Ken Rodman, my colleague, will talk to us today about holding Putin accountable. He is the William R. Cotter Professor of Teaching in the Department of Government. So welcome, Ken. Thank you. I will say real quickly that when we get to Q&A, we've been asked to make sure that we hold a microphone because this is being simulcast and is being recorded. So without further ado, my colleague, Ken Rodman.
So if you look at the statements of Western leaders regarding Russia's invasion of Ukraine, there's a potential tension between legal ambition and political strategy. On the one hand, many have declared Putin to be a war criminal. In fact, President Biden the other day accused Putin of genocide. And the implication of this is that as a criminal, he's not a legitimate interlocutor in negotiations and should be shunned or outcast until he's removed from office. On the other hand, the stated purpose of the sanctions and the military support for the Ukrainians is to raise the costs of the Russian invasion to a point where they seek a negotiated exit, and to do so in a way that minimizes the risk of escalation and direct confrontation between two nuclear powers. These are goals that require communication and negotiation with a government whose leader, at least rhetorically, has been criminalized. And the tension between these two goals is reflected in two different strands of international law. Traditional international law that emerged in Europe in the 17th century tries to further the latter goal by providing absolute personal immunity to heads of state and diplomats from foreign prosecution, and immunity from other public officials for what they do in their official capacity. And the idea here is to enable states to better be able to manage their conflicts. To use a Cold War analogy, imagine the situation if during the Cold War, the United States could bring charges against Soviet leaders for the gulags, or Soviet prosecutors could bring charges against the United States for war crimes in Vietnam. It would be very difficult for them to communicate with each other and manage their differences. However, beginning at Nuremberg and expanding in the 1990s with the International Criminal Court and the Pinochet case, you see the emergence of this new international law of justice and accountability, which equates immunity with impunity and demands the prosecution of those responsible for the worst crimes. And these two bodies of law uneasily coexist with each other in large measure because each represents legitimate values: diplomacy and managing relations between states, and human rights and justice. Well, my talk today will explore the tensions regarding these two strands of international law as it applies to Ukraine. And then I want to examine some of the political implications of prosecution. But before we do that, I want to begin by talking about the law, and begin with a simple question. What is a war crime? We talk about war crimes all the time. What do we mean when we talk about war crimes? Well, within international law, there are basically two bodies of law that cover war crimes: jus ad bellum, law of war, or jus in bello, law in war. Law of war deals with the circumstances where it is legal or illegal to use force. And the crime for violating jus ad bellum is the crime of aggression. Sometimes it's referred to as a war crime, but technically war crimes and aggression are different. Now, there was no such thing as jus ad bellum or the crime of aggression before the 20th century. But with the League of Nations, the Kellogg-Briand Pact, the United Nations Charter, you saw international laws that addressed this issue, but they involved state responsibility, not individual criminal responsibility. Some of those laws were used to prosecute German and Japanese leaders after World War II. But as of today, those are the only prosecutions we've seen so far for the crime of aggression, even though the crime of aggression is part of the Rome Statute for the International Criminal Court. Let's turn to the next body of law, jus in bello, the law in war. This is what's technically referred to as war crimes. And it emerged as a result of customary international law in Europe in the 18th and 19th century and was later codified in Europe beginning in the late 19th century. And if you want to understand jus in bello, if you want to understand, international humanitarian law, you could go over all of the treaties, but you basically have to understand three principles, and everything else is commentary. Military necessity. Armies are allowed to do what is necessary to win the war. That is, they can attack the soldiers of the other side. They could hit objects that make a contribution to the military effort. The principle of discrimination or distinction. While it's legitimate to hit combatants and military objects, intentionally targeting civilians or civilian objects like hospitals or schools or museums is forbidden. And the principle of proportionality. Civilians will inevitably be harmed in any war, but to be legal, the military advantage of a particular strike has to be disproportionate to the civilian harm that's inflicted. Well, who enforces the laws of war? When they were first developed, militaries were supposed to incorporate them into their military codes. They would create military justice systems, although there was a tendency to be somewhat self-partial. It was their crimes and our misdemeanors. And sometimes when you captured enemy soldiers who were responsible for war crimes, normally they'd have a right to be repatriated. But if they committed war crimes, they could be prosecuted, though that was most likely to happen when one side defeated the other. Nuremberg and Tokyo were largely the result of one side defeating the other, since those two tribunals were established under occupation law, even though the Allies committed violations of these principles of jus in bello through the firebombing of German and Japanese cities, let alone Hiroshima and Nagasaki. Or as one military lawyer once put it, the first rule of the law of armed conflict is, don't lose. But that raises an interesting question. Is it possible to establish international bodies that are more independent in meting out accountability? And you began to see a number of developments along those lines in the 1990s. And I'm going to talk about two of them that are relevant to the Ukraine case. The first is the International Criminal Court, whose founding Rome Statute was negotiated in 1998, and it became the first permanent tribunal to hold individuals accountable for the worst human rights abuses and atrocity crimes, but only when national systems of justice were unwilling or unable to genuinely investigate or prosecute. The court currently has 123 state parties. Then there's a practice called universal jurisdiction, where some states, mostly in Europe, enacted laws that gave investigating magistrates the ability to bring charges against universally reprehended crimes, the most famous example of which was a Spanish arrest warrant for the former Chilean dictator Augusto Pinochet and the 16-month extradition controversy in the United Kingdom, where it was determined that Pinochet, as a former head of state, lacked the immunity to prevent his extradition from Spain to stand trial, even though Pinochet was eventually sent back to Chile for health reasons. And if you've been following the news, just a month or two ago, a German court prosecuted and convicted Anwar Raslan, a former Syrian secret police officer who fled to Germany after the war and then was identified by refugees as a perpetrator. So let's begin by looking at the International Criminal Court. The first question you have to ask in terms of the ICC's investigation of the Ukraine war is, does it have jurisdiction? And in asking that question, it's important to note that neither Russia nor Ukraine are state parties to the Rome Statute. They're not members of the court. And the Russian Foreign Ministry has put out a statement saying, since Russia is a non-party to the court, since it hasn't consented to the court has no jurisdiction. And it's not an argument completely without merit, because international law is consent-based. Nonetheless, there are provisions of the Rome Statute that allow the prosecutor to investigate non-party states if they commit crimes over the territory of a state that consented to the court, either because that state is a party to the court, or because it issued what's called an Article 12.3 declaration, which allows a non-party to allow the ICC to have jurisdiction for specific periods of time over specific conflicts. In 2014, Ukraine, as a non-party, made 2 such declarations giving the court jurisdiction. There's an interesting irony in this, given that the United States publicly supports an ICC investigation. Because the United States at Rome in 1998 cited jurisdiction over non-party states as one of the 4 reasons why it voted against the Rome Statute. In fact, the legal position that the United States presented at Rome was identical to the legal position put out by the Russian Foreign Ministry. And these rules of jurisdiction in the Rome Statute led to investigations that the United States strongly opposed. The investigation of American war crimes, the use of torture in Afghanistan. Afghanistan is a state party. And the investigation of Israel for the 2014 Gaza war, since the Palestinian Authority used the same device that Ukraine used to give the court jurisdiction. Now, the American position was rejected at Rome. The argument is that this is consent-based. The consent comes from the territorial state that has jurisdiction over crimes on its territory, and it was simply delegating that jurisdiction to the ICC. That was the view that was adopted at Rome. Though had the American view prevailed, well, I'd have to cut out the next 3 pages of my lecture. Next issue. What are the crimes over which the court has jurisdiction? And there are 4: genocide, crimes against humanity, war crimes, and the crime of aggression. I should note that even though genocide and crimes against humanity are often referred to as war crimes, technically they are not, because they do not require a nexus to armed conflict in order to kick in, even though these are acts that often take place within the context of an armed conflict. So let's look at potential prosecution of each of these crimes. First, aggression. Aggression is probably the easiest crime, at least in principle, to prosecute, because aggression is a crime of leaders. It involves the decision to wage an illegal war. And it's the easiest crime to attribute to Putin and his inner circle. Yet the court will be unable to prosecute Putin for the crime of aggression. Why? Well, as in the case of jurisdiction over non-party states, aggression was another of the 4 stated reasons why the United States voted against the Rome Statute. The American view was either aggression should be kept out of the Rome Statute, or you should only be able to prosecute aggression when it's determined by the UN Security Council, where the US and also Russia have a veto. And as a result of lobbying and a number of other differences, aggression was included in the Rome Statute, but it wasn't defined. The court was not allowed to investigate and prosecute aggression for its first 7 years. Then in 2010, you had the Kampala Review Conference that was designed to add the crime of aggression. Even though the United States was a non-party, President Obama sent his State Department legal advisor to try to lobby against the inclusion of the crime of aggression. He didn't fully succeed, but he did contribute to the definition of a crime of aggression that is only applicable if a state party opts in. And not opts in terms of being a victim of aggression, but opts in terms of accepting jurisdiction if one is guilty of aggression. And there are 43 state parties that agreed. The country with the largest military is Spain. From the US perspective, this basically meant that, well, we may engage in some controversial uses of force abroad, but largely this definition immunizes us from legal scrutiny for those decisions. But what applies to the United States applies to Russia as well. Let's turn to the next charge, genocide. Interestingly, Russia used the charge of genocide as a way of justifying the war, that there was a genocide in eastern Ukraine against Russian speakers, which turned out to be a tactical mistake, at least in legal terms, because Russia and Ukraine are both state parties to the Genocide Convention. There's a provision that says if there's any dispute in terms of interpretation, it's settled by the International Court of Justice. So Ukraine, took Russia to the International Court of Justice. Russia tried to say, well, we didn't mean genocide in the terms of the convention. We were just using it as a rhetorical term. But the ICJ issued a preliminary ruling that Russia's intervention was illegal. Well, what about the other side of the coin? Is Russia involved in a genocide towards Ukrainians? At one level, you don't have the degree of exterminationist and mass killing that you saw during the Holocaust or the Rwandan genocide. But if you look at the definition of the genocide, these are acts committed with the intent to destroy in whole or in part a national, ethnic, racial, or religious group. Think about Putin's rambling speech before the Ukraine invasion, saying that there's no such thing as Ukraine, and basically the war is designed to, coerce the Ukrainians into, believing that they're actually Russians. Think of some of the statements that have come from state-controlled Russian media, which have called for long-term occupation, forced labor, the killing of large numbers of the Ukrainian elite as a way of, Russifying Ukraine. Or I was just reading a BBC report yesterday with some of the rape survivors in Bucha, who were told by Russian soldiers that now you're not going to want to have sex with a man and you're not going to be able to have Ukrainian babies. When I teach about war crimes trials in Rwanda and Bosnia, this is the kind of testimony that was often provided to the tribunal. They are indicators of genocidal intent, if not genocide itself. And while the tribunals have been reluctant to actually convict on the crime of genocide, much of this evidence makes a fairly strong case for attempting to prosecute on these grounds. And this is something that could also be attributed to the senior leadership. For the next set of crimes, I'm going to sort of lump together war crimes and crimes against humanity. Crimes against humanity exist in wartime when you're dealing with war crimes or forms of persecution that are widespread and systematic against the civilian population. And a lot of what we've seen in Mariupol, in Bucha, and elsewhere fall within the Rome Statute. And cases can be built against Russian soldiers and commanders whom, if charged, would not be able to travel to Rome Statute state parties without risking arrest. And hopefully this might have some deterrent impact if the court were to act along these lines. But that raises an interesting question. Can you attribute the war crimes to higher-ups? Or does the responsibility simply reside with soldiers and commanders? On the one hand, you can argue the systemic nature of many of these crimes would allow us to infer responsibility to Putin and the senior leadership. And if you look at the Russian way of war in the bombing of Aleppo in the Syrian civil war, or Grozny in the civil war in Chechnya, a case can be made that there's a pattern of behavior. And people who make this argument point to the only Japanese war crimes trial that's had any impact on subsequent legal developments. And that's the trial of Tomoyuki Yamashita in an American military commission in Manila in 1945. Yamashita was the Japanese general who was in charge of the occupation of the Philippines. As American troops were advancing on Manila, he called upon his forces to withdraw. But those instructions couldn't be relayed because the general who was supposed to deliver them was taken out by an American airstrike. And the Japanese troops with no instructions went on a rampage, killing, raping, looting. When communications were reestablished, Yamashita was shocked that the Japanese troops were still there and ordered them to withdraw. But when Yamashita was surrendered, he was prosecuted for the actions of his soldiers. And the theory underlying this was command responsibility. These were his soldiers. He trained them. He's responsible for their behavior. And there was a pattern of Japanese war crimes against civilians. For many human rights advocates, even though they recognize Yamashita came from a bad seed, I mean, this was set up by MacArthur and the verdicts were announced on December 7th, 1945, the 4th anniversary of Pearl Harbor, payback. This was seen as a way of connecting atrocities on the ground to the higher-ups. It was one of the things that some human rights lawyers used to try to connect the behavior in Guantanamo at Abu Ghraib to Donald Rumsfeld and his superiors. And some of the early decisions of the international tribunals drew on versions of the Yamashita precedent and arguing that leaders were aiding and abetting war crimes. But this approach to law also led to something of a backlash, in that this was something that was making it too easy for prosecutors. Some people defined international human rights law in terms of holding people accountable. Others argued that that was necessary, but it was also necessary to protect the rights of the accused. And beginning in 2014, this is the Perisic appeals judgment, a 27-year sentence imposed on the chief of staff of the Yugoslav military was vacated. Why? Because they could not find evidence of specific direction that Perisic had given to those who were responsible for the crimes on the ground. And there were a whole series of acquittals or convictions that were reversed in the ICTY, the International Criminal Tribunal for the former Yugoslavia. And the ICC judges increasingly used these arguments as well. Probably the most prominent case was the acquittal of the former president of Cote d'Ivoire, Laurent Gbagbo. Every NGO report I read argued that after the election, when he refused to step down, he was responsible for the post-election violence against supporters of the other side. But after a 7-year trial, the judges determined that there was insufficient evidence to directly connect Gbagbo to the violence. So it may be difficult to connect the war crimes on the ground to Vladimir Putin and his inner circle. But maybe you can. But there's another insuperable hurdle that the ICC would have to overcome. And that's foreign sovereign immunity, something I talked about in the beginning of my talk. Sovereign immunity, the idea that heads of state have absolute immunity from foreign prosecution, is the default option. It's customary international law. If a state party joins the ICC, if you consent to its jurisdiction, well, look at Article 27.1. This statute shall apply equally to all persons without distinction based on official capacity. I am consenting to immunity is irrelevant if someone in my country who has immunity is complicit in these kinds of crimes. But that raises an interesting question. Non-parties as well as state parties can fall within the ambit of the ICC. They haven't explicitly consented to the immunity of their public officials being overridden. Who was concerned about that? The United States. And as a result, the United States incorporated Article 98.1 into the Rome Statute, which effectively says that if you're dealing with a third state, a non-party that falls under the jurisdiction of the ICC, you cannot issue a request for arrest and surrender that violates existing immunity. In other words, the United States was taking the position that, yes, we might fall within the ambit of the ICC, but we haven't consented to this. And therefore, an American president, American high-level official, even if it fell under the jurisdiction of the ICC, would be effectively immune from arrest and surrender. But the incorporation of Article 98.1 not only protected high-level American officials from this, but Vladimir Putin as well. Well, next issue, what about universal jurisdiction? What about national courts, mostly European courts, exercising jurisdiction over these universally reprehended crimes? There was some optimism about this after the Pinochet case. The British law lords in the Pinochet case argued that Pinochet, as a former head of state, was no longer protected by sovereign immunity, and therefore he could be sent to Spain to stand trial, even though the crimes for which he was being prosecuted were against Chilean citizens on Chilean soil. As it turned out, the Pinochet case was the high water mark for universal jurisdiction. And its ambitions were somewhat truncated by a case before the International Court of Justice called Belgium versus Congo. So Belgium versus Congo involved Belgium using its universal jurisdiction law to issue an arrest warrant for the foreign minister of the DRC, who had given an incendiary speech in Kinshasa, and he was charged with incitement to genocide. The DRC challenged that law before the International Court of Justice, and the International Court of Justice agreed. Yes, a former head of state may have lost his immunity for these kinds of crimes, but a sitting foreign minister, someone who currently has immunity, cannot be tried in national courts. That person can only be tried if it's an international tribunal, after that person steps down, or if the state consents to that person being tried. Well, what applied to, I forgot to click the next slide. What applied to Eurodia, the former Congolese foreign minister, also applies to Vladimir Putin. That is, universal jurisdiction might apply to former heads of state. The one African case that I'm familiar with is the trial of the former Chadian dictator Hissène Habré in Senegal. It might apply to people who don't have immunity, who are fleeing from civil wars, but who are also perpetrators, like Anwar Raslan and a number of Bosnians and Rwandans. But it can't be applied to Vladimir Putin. So, recognizing some of the roadblocks in the law, both for prosecuting aggression and for overriding sovereign immunity, a number of lawyers, NGOs, and politicians have put forward a number of proposals, amending universal jurisdiction laws to deal with the crime of aggression, creating a special tribunal through the UN General Assembly, creating a tribunal through the Council of Europe, or creating some kind of hybrid court with the Ukrainians themselves. And I think this could play a useful role in further stigmatizing Russia and rallying the coalition against it. I'm skeptical of some of the legal arguments that are made on behalf of the proposals, but I think there are also prudential reasons why the criminalization of politics might be imprudent at this stage in the conflict. And what I'd like to do is lay out 3 reasons why I have these prudential reservations about introducing international criminal law right now. Reason number 1. Criminalization, international prosecution, is premised on either military victory or regime change in Russia. The first is too dangerous in the nuclear age. The second is unlikely, given the nature of current Russian politics. And this was something that was laid out in one of the 6 University of Chicago speeches made by George Kenan in 1951 that was later turned into this thin book that people of my generation read in foreign policy courses. But I want to read you this passage, which is Kenan's critique of legalism. Whoever says that there is a law must, of course, be indignant against the lawbreaker. And when such indignation spills over into military contest, it knows no bounds short of the reduction of the lawbreaker to the point of complete submissiveness, namely unconditional surrender. It is a curious thing, but it is true that the legalist approach to world affairs, rooted as it is unquestionably in a desire to do away with war and violence, makes violence more enduring, more terrible, more destructive. The criminalization of the enemy in World War II required total war for unconditional surrender. Given the radical evil of Nazi Germany, I think that was justified. Nonetheless, that's something that has to be acknowledged. Or if you look at other successful international criminal tribunals, what empowered the International Criminal Tribunal for the former Yugoslavia was bombing campaigns. In Bosnia in 1995, and Kosovo in 1999. The reason why the architects of the Rwandan genocide were prosecuted was because they lost the civil war to the Rwandan Patriotic Front. The reason why there was a special court for Sierra Leone was because Britain intervened in Freetown during the Civil War. And I could give you a number of other cases where these kinds of military actions were necessary in order to empower international prosecution. Well, while the Ukrainians are resisting militarily with Western assistance, it's hard to imagine the circumstances that would lead to the replacement of the regime or a defeat of the Russians in a way that would make Putin vulnerable to prosecution. And that leads me to my second reservation, what's often referred to in the study of international criminal law as the peace versus justice problem. If Putin is not removed from power, ending this war will probably involve some kind of negotiation with Russia. That's the premise of the sanctions and military assistance to Ukraine. It's what we call in the security studies literature coercive diplomacy. You're imposing added pain on Russia through sanctions, through increasing Ukraine's military capabilities, so at a certain point, it decides that the costs of war exceed its benefits, and that way you have some kind of face-saving exit. Sanctions are an appropriate instrument in trying to bring that about because they could be calibrated to the degree of Russian compliance. Whereas prosecution isn't, because when you're prosecuted, you're a criminal. That's it. You're an unperson with whom one cannot negotiate. To give you an analogy, look at the role of Slobodan Milosevic in ending the Bosnian War in 1995. Probably no one was more responsible for Milosevic, who would later be charged for the ethnic violence in the former Yugoslavia. No one was more responsible than him. But in 1995, the United States wanted to end the war. How did it do that? By ratcheting up the sanctions, by launching a 17-day bombing campaign called Operation Deliberate Force, and by secretly, and by the way, also illegally, arming the Croatian and Bosnian armies so as to convince Milosevic that he was overextended. The longer the war went on, the worse he would be. And it was in his interest to compromise and end the war. If you had added prosecution to this, in effect saying, oh, and by the way, we're also going to want to arrest and prosecute you in The Hague, it would be impossible to reach a settlement. In other words, coercive diplomacy is designed to inflict pain on a target to a point where it decides that compliance with your demands is in his interest. When you say that the person is a criminal with no alternative but to be sent to The Hague to be prosecuted, that kind of cooperation is impossible. Third reservation. We're entering into a period of intensified great power competition, not only with Russia, but with China as well. That means we need to think about issues like containment and deterrence, but it also requires us to communicate, to develop understandings, to engage in arms control and other forms of cooperative security that stabilize the relationship and prevent conflicts from getting out of control. And the reason for that is because of a political science concept called the security dilemma. Many of you in Government 131 read some of the late Robert Jervis's, seminal work on the security dilemma. And what Jervis argues that there are these circumstances where countries take actions that they see as defensive or they see as limited, but others see them as threatening. And that can contribute to a kind of conflict spiral that in turn could get out of control, as happened during the First World War. Well, those are issues we needed to think about during the Cold War, but also issues that we need to think about given our current predicament. Let me give you a Cold War example. And I'm teaching a course on the Cold War next semester, so I'm going to sort of gratuitously, use an example that I cite from the class, but it's one of the most important episodes in the late Cold War that most of you are probably not familiar with. It's called Able Archer 83. In the early Reagan administration, Reagan gave that speech referring to the Soviet Union as an evil empire, and there were some members of the Reagan administration, not for international criminal law reasons, but for ideological reasons, that saw the Soviet Union as so beyond the pale that they're a country with whom we shouldn't negotiate. That actually wasn't Reagan's actual approach, but nonetheless, this was the approach of his most hardline advisors. Well, in 1983, NATO conducted a military exercise called Able Archer 83, part of which simulated a potential attack on the Soviet Union or on the Soviet bloc. And what we didn't understand at the time was, while we were referring to the Soviet Union as the evil empire, the Soviets were using 1930s Germany analogies, not just in terms of the way they were characterizing the United States, but in terms of arguing that this was the period where the risk of war was greatest. As a result, during that exercise, the Soviet Union went on its highest stage of nuclear alert that it had been on since the Cuban Missile Crisis. And that was communicated to the Reagan administration by Oleg Gordievsky, the highest-ranking Soviet double agent who was working for the United States. And Reagan was somewhat shaken by this. He writes about it in his memoir. 3 years, it taught me something surprising about the Russians. Many people at the top of the Soviet hierarchy were genuinely afraid of America and Americans. Perhaps this shouldn't have surprised me, but it did. The more experience I had with Soviet leaders and other heads of state who knew them, the more I began to realize that many Soviet officials feared us not only as adversaries, but as potential aggressors who might hurl nuclear weapons at them in a first strike. Because of this, and perhaps because of a sense of insecurity and paranoia with roots reaching back to the invasions of Russia by Napoleon and Hitler, they had aimed a huge arsenal of nuclear weapons at us. Well, if that was the case, I was even more anxious to get a top Soviet leader in a room alone, try to convince him that we had no designs on the Soviet Union and the Russians had nothing to fear from us. Now, I'm pretty sure that Reagan never read Robert Jervis. But this is an acknowledgement of the security dilemma in his kind of disarming, aw shucks sort of way. And actually, the first negotiation the United States had with the Soviet Union, or the first treaty that was negotiated in 1986, was something called the Stockholm Agreement, where the Soviets and the Americans agreed to greater transparency in terms of their military exercises in order to prevent the recurrence of a crisis like the one that had just happened. Similarly, in the increased confrontation between the United States and Russia over what's going on in Ukraine and Eastern Europe, there's a significant risk of miscalculation. Russia could intervene in some of those areas adjoining Ukraine, which are NATO members, in order to, staunch the flow of arms to the Ukrainian military. The United States might escalate its involvement in Iran that might, in the Russian view, cross certain red lines. When you criminalize the enemy, it's more difficult for you to communicate with the enemy or the adversary as a way of reconciling your differences. So that's the final reservation I have about this issue of criminalization. Now, I want to say in conclusion that I'm pretty uncomfortable expressing these reservations, particularly when I watch TV or read the news and hear the testimony of witnesses, victims, or I hear the relentless gaslighting of Russian public officials and saying that murder is not murder. And it's an area where the liberal and realist parts of my brain are, if not in war with each other, at least in conflict with each other. Is the international system one where we should make moral judgments? Or is it one where you need devices like immunity in order to enable countries to reconcile their differences and influence each other's behavior? And the answer is that it's both. And my intent in expressing these reservations and making this argument is not to deny the moral imperative of reversing Russian aggression. But I would argue that the moral imperative now isn't justice. It's stopping the violence, ending the war. And this requires not creating new judicial instruments. The creation of the ICTY, the International Criminal Tribunal for the former Yugoslavia, didn't end ethnic cleansing. In fact, when it was first created, it was an alibi for inaction. Rather, in responding to the moral imperative to do something, what's needed is to double down on financial and military instruments that are being deployed to make the war as costly as possible for Russia, just as the sanctions, the military strikes, and the arming of the Croats and the Bosnians was designed to make the Bosnian war as expensive as possible for Milosevic. And if the underlying strategy is coercive diplomacy, that means you have to give Russia an off-ramp. And criminalization makes that kind of compliance difficult. Or to quote Jack Snyder and Leslie Vinjamori's classic essay on pragmatic approaches to war crimes trials, justice doesn't lead, it follows. In other words, the kind of justice that's possible is a function of the political strategies that are used to end the war, and unless those strategies can push Russia out of Ukraine without negotiation and undermine the regime, ending the war will require some degree of pragmatic bargaining, and Putin won't be going to The Hague. And with that, I will take your questions. Don't clap that Putin's not going to The Hague, because I would certainly like to see that. I should have thought of a better last line.
You were speaking about, as clearly as you're saying, that Putin won't go to The Hague, but is there any possibility of other Russian leaders, like generals or such, going to The Hague?
The ICC has jurisdiction over war crimes. Soldiers and commanders don't have immunity from prosecution, so therefore, cases that are brought against soldiers and commanders that are responsible for, let's say, the bombing of Mariupol, or the execution of civilians in Bucha are certainly vulnerable to prosecution. Getting custody over them is somewhat more difficult because they're likely to remain in Russia, But if they're charged by the International Criminal Court, if they travel to any Rome Statute state party, they would be vulnerable to arrest and surrender to the Hague. So under existing law, the ICC would be able to build cases against soldiers and commanders, but it wouldn't be able to build cases against those who would otherwise have immunity in customary international law. I think there's a hand over there.
I'm curious about the Russian political structure. You referenced briefly that it's unlikely to change. I'm curious as to why that is. Are the people so gaslighted, as you said, that they can't see through all these crimes? Or could you just shed a little bit more light on that for me?
Well, I don't think it's a matter of public opinion primarily. I'm not an expert on Russian domestic politics, though I've been reading a lot about it recently. Some people speculated that, targeting the oligarchs, the economic elite within Russia, might put pressure on Russia. I don't think public opinion is going to do that. But those oligarchs, those economic elites are much more dependent upon Putin than he is on them. It's not as if he's some kind of figurehead that's trying to, promote the interests of, a powerful economic elite. They're largely within his control. It's certainly possible that this war might turn into such a disaster that, the military or the security forces might turn against him. But for most of the Russia experts that I read, I think that's somewhat unlikely. Though it's also a prerequisite for making him vulnerable to prosecution.
Hi. So I have a question. I'm Lindsay Make, Associate Professor, Government, for those who don't know me.
Yes, I know you.
You know me, but the students. Okay. So you ended this with, in some ways, a very compelling argument for the moral imperative that the focus is on ending the atrocities right now. However, should we and can we really think of this as an isolation? If we allow this to continue, could there not be more in another case later on if we take that route out of just the negotiation?
So I'm not quite sure I understand the question. That ending this war in Ukraine will not necessarily end the conflicts that we see with this, that we may see a further intervention in other places where you see the same sort of atrocities, and therefore doing something to stop Putin now and find justice for that could perhaps prevent future atrocities. But what would doing something mean? If you're going to, issue criminal indictments of Putin right now, you would basically be, let's assume you could do that legally. And there are a number of hurdles you have to overcome in order to do that. You would basically be isolating Putin within Russia. That wouldn't necessarily prevent him from using force in other places. I think one of the problems with, the argument that I'm making is a negotiated solution possible? And I'm not clear that it is. If Putin were the kind of great power realist that John Mearsheimer thinks he is, then maybe some kind of agreement for Ukrainian neutrality, would work and stabilize the situation. Though it's very difficult to both guarantee Ukrainian neutrality and then reassure Ukraine of its security vis-a-vis Russia. It's almost like, the irresistible force meets the unmovable object. I mean, you're dealing with situations that seem somewhat incompatible. But I'm not sure that you could argue that by not criminalizing Putin, it's giving him an opportunity to do this again. But existing international law makes that difficult, if not impossible. And again, I think when you're dealing with to relate it to a broader argument that I've made in some of my writing, when you're dealing with an ongoing war, your primary focus shouldn't be on criminal justice. It should be on trying to end the war. And how you end the war determines what kind of justice is possible. So I'm not sure if I fully
I think it's
answered your
more,
question.
is this Russia, or sorry, is this Germany in like the 1930s going in and then having that spiral into more?
Right, but Nuremberg didn't stop the Nazis. I mean, it was the willingness to fight a total war for unconditional surrender. The hope after Nuremberg was that by criminalizing that behavior, you'd have a deterrent impact on others. Although I think the underlying reason for why Nuremberg took place was as a way of sort of denazifying Germany and transforming it into a more rights-respecting democratic ally.
This war, since the beginning, has basically been live streamed on social media. Do you think that will play an impact on the amount of evidence or thoughts that people are having around the world that might play a part in the trial of Putin if one was to occur?
Social media in terms of what specifically?
Different types of posts and images of people posting them from Ukraine.
I think the social media helps us understand what's going on, but the kind of, and will shape public perceptions. But one has to be very careful with these things when we're talking about the evidence that you would use in a court of law. You can't use evidence on social media in a trial. Well, I guess there are circumstances where you maybe can, but if you're looking for evidence of war crimes, the ICC has its own investigators that it sends on the ground to determine what's going on, and that's the kind of evidence that you would use in a court of law. One has to be very careful in terms of what you look at on social media, because at one level, it could give us a window into the kinds of war crimes that are taking place, but they could also be manipulated, whether you're dealing with issues of war crimes or you're dealing with political issues here in the United States.
My question, I guess it's sort of a two-part question. The first is, how do you know when your sanctions are enough? You know, I think there's a, maybe that's the impossible sort of question, but how do you know when you, excuse me, when you've gone to the correct point with sanctions? And then the second part of that is that, do you fear sanctions could provoke nuclear conflict?
How do you know when sanctions are enough? I mean, you don't. You look at the degree to which the target of those sanctions is willing to make concessions that it wasn't previously willing to take. It's not something, I mean, there are some interesting debates as to whether or not, you know, we're moving towards, let's say, oil sanctions or energy sanctions, even though they're likely to be costly to the senders as well as the target. But the truth is you don't. And there are many cases where we've imposed horrendous sanctions on countries, I mean, Iran, Venezuela, others, where we haven't achieved, you know, at least recently, much in the way of compliance. Now, in terms of your second question, sure. In theory, sanctions could lead to war. In fact, the 1941 sanctions against Japan helped influence the Japanese to decide to attack Pearl Harbor, the American bases in the Philippines, and the British bases in Singapore simultaneously. The reason they did that was because they cut off oil and steel. Japan decided that it needed to control, Indonesia, some of the former European colonies, in order to maintain access to that steel. The seaways would be vulnerable to the United States and the British. So in effect, the United States' decision to impose sanctions on Japan basically settled the issue in the Japanese War Cabinet to, attack Pearl Harbor. So there are some circumstances where that would happen, but it's difficult for me to see how the sanctions that are imposed on Russia right now would lead to some comparable decision to take over some region that, they need in order to compensate for the sanctions that were imposed. So it certainly is a possibility. But I think that the two situations aren't entirely analogous.
The ICC has recently faced, recently in the past 20 years, kind of a crisis of legitimacy in many ways. And I feel like this case regarding Vladimir Putin is just another manifestation of this, where he's been largely unable to prosecute those most potentially high-profile war war criminals around the world. I'm curious, considering that, at least as you believe, that the ICC will be unable to take action against Vladimir Putin, what's next for the ICC in its process of potentially trying to protect international human rights, while also simultaneously being unable to prosecute those who really are behind some of the most atrocious human rights instances we've seen in the past 25 years?
Well, I think the issue with the ICC has less to do with the court as an institution, though the court as an institution has some problems, and has more to do with the broader politics of international relations and the politics of the conflicts with which it's dealing. As I was alluding to earlier, international criminal justice tends to be most effective when one side defeats the other, and the losers are sent to The Hague to stand trial. For the most part, the winners remain immune. Sometimes when you're dealing with civil wars where you have groups that are responsible for atrocities, well, the way you end those civil wars is through negotiations. And it's very difficult to negotiate with your adversaries and demand their prosecution at the same time. So I think a lot of the problems that the court has stem from that issue. Where the court has been most successful is where its investigations have coincided with interventions. The UN, sometimes, in alliance with, Western governments, intervening in those countries. The case of Cote d'Ivoire I mentioned. Although Gbagbo was acquitted, he was sent to The Hague. Why? His side lost the civil war, and you had a UN mission supported by French troops that assisted the other side in gaining power. And even though the other side was responsible for some atrocity crimes as well, although, Gbagbo was the one who had engaged in the illegitimate behavior, the fact is the court tends to be empowered when strong and powerful states are willing to back it up. Now, this is an interesting paradox for the court because some of the strongest supporters of the ICC wanted a court that was independent of politics. The US wanted a court that was connected to the Security Council, so it would be an instrument of great power influence. The NGOs wanted a court that was independent. But in many ways, the court has acted like a court that's been tethered to the Security Council, Russia perhaps being an exception, because in large measure, it's dependent upon powerful and wealthy states in order to be effective.
Happy to take it. Thanks, Ken. So, if you could speculate, if you could prescribe, given what you've laid out, some of the uncertainties about when sanctions are effective, when do you know they're effective, the tensions within international law, where do we want Russia to go? How do we want this to end? I mean, thinking about what is the best case scenario for Ukraine or the West or the international system, whatever, but is still likely to occur given that Putin's probably not going anywhere. Is that something that, well, you've probably had some thoughts about this. I'd love to hear
Yeah,
them.
I mean, the best case scenario is, Russia decides to withdraw from Ukraine in exchange for, some kind of Finlandization agreement where, Ukraine agrees to neutrality, in exchange for Russia withdrawing. I'm not sure that would necessarily work. One of the points I was making earlier, and we were talking about this in my seminar, if Putin was a great power realist who was just concerned about potentially hostile powers on his, in his near abroad, then there's probably a kind of negotiated settlement that could be entered into. You could do something along the lines of the Finland solution. Henry Kissinger wrote an oft-quoted op-ed during the 2014 crisis. I'm not sure that that's what Putin's goal is. I think he's much more motivated by Russian nationalism, a sense of personal grievance. I think it's going to be much more difficult to enter into some kind of, negotiation. The likes of which you eventually saw in, Bosnia and ending the war. So even though I'm arguing that some kind of negotiated exit is the only game in town, I'm somewhat pessimistic about that being brought about. So I'm not sure if that was a satisfactory answer. It certainly isn't in terms of policy, but I think the ideal situation is one where the pressure is ratcheted enough to a degree that he calculates that it's in his interest to withdraw. But then the question is, can you create an agreement that both saves Russia's face by making Ukraine neutral, while at the same time reassures Ukraine in terms of its security? In my seminar the other day, we were teaching about the nuclear weapons that Ukraine inherited at the end of the Cold War, and I could see Ben over here nodding his head. And one of the agreements that was made with Ukraine in order to reassure them after giving up those weapons was something called the Budapest Memorandum, which involved these, vague hortatory statements about respecting Ukraine's territorial integrity. It wasn't a binding Article 5 commitment. But it may be one of those situations where, there's nothing in common there's no overlapping part of the Venn diagram. Which means that we're probably in for a long, painful war.
I wanted to ask specifically about other international organizations like the HRC, the Human Rights Council. Now that the United States is back in the council under the Biden administration, is there any other agencies that are trying to resolve or bring this up to the table for human rights?
The UN Human Rights Council voted overwhelmingly in favor of creating a commission of inquiry to investigate war crimes, similar to commissions that have been established in other cases. But it's important to note that these UN bodies are not enforcement bodies. They don't make legal judgments. They operate through social pressure and naming and shaming. So basically, the evidence that's presented by these bodies may play a role in prosecution at some point down the line, but their primary purpose is to, use soft power to stigmatize Russia for the, actions it's taking in Ukraine.
I think we have time for one more. Is there another one, Ben? Did you see? Maybe one or two.
I have a kind of a broad question about kind of the implications of what this war and the potential ways it might end mean for the international system in a large sense. Because it feels like, since the end of World War II, we've entered, or definitely since the end of the Cold War, this kind of this moment where it seemed a lot less like we're living in a world where it's just like might makes right, and I can invade this country and wipe it off the map, as opposed to, obviously that's what Russia's stated goal is, that they don't believe that Ukraine is really a country and that as such doesn't matter that they're invading. And I guess I was wondering, given what seems to be from this talk, the likelihood that Russia as a nation, Putin as an individual, will leave this conflict kind of whole, like it won't be the kind of total war, defeat of Nazi Germany, defeat of Japan that ended World War II, where it was kind of a very clear, like, you broke the rules, you will be punished. What does this mean for the future of international peace? Like, are we moving back into a world where might makes right? And if you have nukes and if you have a big army, you can't be punished for trying to invade your small neighbor? Or are we always in that world and we just kind of had the mistaken belief that we had these international systems and these laws that prescribed behavior in a way that just simply was kind of a mirage, if that makes sense?
I think that creates a large issue. We were reading in the seminar, any of you are curious, I could give you the links, an article by Tanisha Fazal on how Putin's invasion of Ukraine challenges these norms, in that in the 19th century, states often disappeared. The idea of going to war with other states to carve out pieces of territory as your own was normal. That was how international relations operated. And since the Second World War, those are practices that have largely disappeared. And at one level, there's a risk that Russia doing this with respect to Ukraine will set a dangerous precedent that might return us to a different kind of world, or an earlier form of state behavior. And if you look at the issue that way, your strategy should be to treat him like a pariah, to outcast him. On the other hand, that might work at cross purposes with the need to, engage Russia. If you're trying to manage, your conflicts with Russia, or you're trying to find some negotiated way of ameliorating the situation in Ukraine, or addressing some potential peace process. But one of the arguments for stigmatizing Russia, and one of the reasons why some proponents of international law would like to see an international commission on the issue of aggression, create an international tribunal with a specific responsibility for aggression, is precisely because they want to stigmatize this kind of behavior, because they want to treat it as criminal, because it would set a dangerous precedent if it were unpunished.
Well, on that depressing note, thank you all for coming, and thank you, Professor Rodman.
I was thinking about it because I adopt a very political, semi-realist view of these kinds of